Hello, I'm Andy Agathangelo. I'm carrying out this video interview of Stephen Barker in my capacity as chair of the Secretariat Committee to the All-Party Parliamentary Group on Personal Banking and Fairer Financial Services. I am also, however, the founder of the Transparency Task Force, which provides the Secretariat to the All-Party Parliamentary Group. Stephen, thank you very much indeed for agreeing to have this conversation with me. As you know, the conversation is being video recorded. The video recording will be placed on the APPG's website and will raise awareness of it through social media and so on. You're carrying out this conversation with me, Stephen, on the basis that you have already provided a written submission to the APPG's call for evidence about the Financial Conduct Authority. Could I invite you, please, first of all, Stephen, to tell us about yourself and outline just briefly to begin with how you came to interact with the FCA. Thank you.
Certainly. Thank you, Andy. Well, my interaction with the FSA and then the FCA began following the mis-selling of interest rate hedging products. It's around that topic that I've had any dealings with the FCA. And in that context, the factual context and outline is that my company banked with the Bank of Scotland, subsequently acquired by Lloyds Banking Group. In 2001, Bank of Scotland provided a 7-year term facility to build and operate a hotel in Manchester. The hotel was built and opened and operated successfully. In 2004, under clause 3 of the loan agreement, the company was obliged to consult with the Bank of Scotland and enter into a financial product offered by the Bank of Scotland, and only the Bank of Scotland, to protect against movements in interest rates. In 2004, the company entered into what was represented as a ISDOR fixed swap. ISDOR stands for the International Swaps and Derivatives Association, and it was for a term of 5 years to June 2009. The 5-year post-construction completion period of the 7-year loan term for the hotel came to an end in September 2009. In early 2008, Bank of Scotland wanted to know what arrangements for repaying the loan or renewing the facility the company intended. In reply, the preference was to renew the facility for another 5 years on similar or better terms. BOSS, I'll call them BOSS rather than Bank of Scotland, but BOSS then said that it believed better terms on the swap could be obtained, and that would make renewing the facility even more attractive to credit, because there would be more left in the cash sweep to repay the capital sum if the ISDOR fix cost rates were lower. There was no hint of hesitation or uncertainty about renewing the loan for another 5 years. Rolling over was the phrase used. The discussions were with senior BOSS corporate banker, a chartered banker of 35 years service with BOSS, as well as a senior FCA registered person from the BOSS Treasury Capital Markets. So these were senior people in the bank that I thought I was dealing with. The 2004 swap was broken and the break costs lent to the company and embedded in the new ISDA fixed swap. It ran until 2013 with a break at year 2, only in favour of BOSS, and then a similar break annually, also only at BOSS's discretion and with no cost to BOSS. The telephone trade took place on the 22nd of April 2008, and ISDA-headed documents for signature were supplied later. By September 2008, BOSS was reportedly insolvent, but unknown to the public, but not the regulator, I suspect, and trading whilst insolvent, according to Sally Matheson's Lord Turner report, of September 2013, released to the public domain by the All Parliamentary Party Group on Fair Banking, page 8 of that report, the executive summary, states HBOS should have been a gone concern in February 2008. It was hopelessly insolvent by July 2008. The corporate banker I dealt with had been elusive during May, June and July, then absent throughout August, and no one else could or would deal with the renewal of the loan. The corporate banker retired from the bank and was not available after September 2008 as the loan renewal date came closer. The Manchester branch of BOSS became, in my view, dysfunctional as Lloyds set about restructuring the newly combined bank. In July 2009, BOSS wrote to the company's statutory auditors in reply to their inquiries under Section 499 of the Companies Act 2006 and clearly indicated he expected a new term facility to be in place by September 2009, the end of the 2001 term loan period. This was to encourage the statutory auditor not to qualify the company's accounts, as they would have to do if the facility was repayable within 12 months from the year end. The facility was not renewed and the account was transferred to the Business Support Unit in Edinburgh. BOSS instructed Grant Thornton to conduct an internal business review, IBR as it's known shorthand, Pinsent Masons, solicitors, to conduct a legal review of the security documentation, and CBRE to complete a valuation of the property. The BSU made it clear they would not renew the loan facility, and so the company appointed KPMG to assist with refinancing the business in the market. Offers of finance were received and completion was scheduled to occur before September 2011. The bank would be fully repaid its debt and the ISDA fixed swap assigned to one of the new lenders. On the 4th of August 2011, BOSS served a demand for repayment of the loan within 1 hour. This could not be done. And so BOSS appointed Grant Thornton employees as administrative receivers by lunchtime. A statement of affairs was produced and 2 licensed insolvency practitioners took over the management of the company. At the first creditors meeting on the last day of the 3 months from their appointment before creditors must be contacted by the administrative receivers, under Section 48 of the Insolvency Act 1986, at which only I attended as a residual creditor, being a shareholder, I was informed that the assets of the company had been sold. All unsecured creditors, trading creditors in other words, the butcher, baker, candlestick maker who'd been supplying the hotel, of which there are around 400, had been taken into the receivership and paid as preferential creditors with the approval of BOSS. BOSS had been fully repaid, including the break cost of the 2008 swap. All professional fees of the process had been paid. There was some VAT to be recovered from HMRC, and there would be no distribution to shareholders. The administrative receivers refused to disclose the sale price of the company's assets. They did so at a later date. The VAT was recovered in due course and taken as fees by the administrative receivers. They refused to resign and wanted to liquidate the company. This, however, could only be done with the consent of the director. I refused. BOSS then said in 2012 there was to be a further review of the mis-selling of swaps under an agreement with the FSA, and the administrative receivers should stay in office. The bank dismissed any claim the administrative receivers may have made under that review. We do not know what role, if any, the administrative receivers played in that review. We believe it was a sham to further run down the statute of limitations clock. The administrative receivers resigned in March 2014. The 2012 FSA voluntary agreement with participating banks, including BOSS, was not published at the time. So we neither knew what BOSS was expected of BOSS or instructed by the FSA to do as part of the review, or how they came to a decision the 2008 swap has not been missold.
Thank you, Stephen. And we're going to move on now to question number 2. What was the arrangement you entered into, with what entity or entities, and when? Okay.
The BOSS term loan, that's the 7-year loan, was from November 2001. It was on a floating 3-month LIBOR rate plus margin. So the interest rate would go up or down as LIBOR went up and down. The swap rate was on an ISDA fixed rate of 2000 in 2004, and then again ISDA fixed rate of 2000 in 2008, April 2008, and both were referenced to the 3-month LIBOR in pounds sterling.
Thank you, Stephen. And question 3 is in 2 parts. If you're happy to mention it, could you please first of all tell us about how much money was involved in terms of the principal amount, and then after that talk to us about the total losses you've experienced? Thank you.
Okay. With regard to the swap, the administrative receivers received a demand of £2,146,000 as a break cost for the 2008 swap. If restitution applied, the balance of all netted off payments until the break would be the basis of recovery. This amount would have to be agreed with BOSS Treasury, although we have records of bank statements and payments made to the bank. We do not believe the swap was ever traded on ISDA, so BOSS suffered no loss on breaking the swap, and indeed we would say made a false claim of a debt to the administrative receivers. Nevertheless, BOSS was paid from the insolvency process the amount stated.
Thank you. And moving on to the second part, the actual total losses.
Well, total losses are substantial. A profitable business was sold not for value, and a foreseeable by BOSS significant consequential loss of chance occurred. The loss is made up of the sale at undervalue, the netted off swap payment from 2008 to 2011, the break cost that I've mentioned already of over £2 million, the loss of chance to sell the asset in the open market because the hotel was not sold in the open market, loss of chance to receive gross profits to reduce debt and increase equity value for shareholders. And as a guide, at December 2015 year end, the purchaser of the hotel in their statutory accounts, based on an independent valuation of the property, put the asset value at 69 million. So it's a substantial loss.
And the company's assets have been sold, I can read your submission here, for 37.5 million. Could you just clarify that part of the submission for me, please, Stephen?
Okay. Well, the disposal price is made up of a number of things, but it's cash that was in the business, as well as furniture, fixture and equipment, because it was a trading business. So it had everything it needed to trade. And indeed it did trade throughout the insolvency process when it was under the management of the administrative receivers. So it was a complete package, and the 37.5 million was broken down into different elements, but that was the amount that was paid. But about $1 million of that was cash. So basically, the actual property itself was no higher than 36 million. And then you've got quite a large allocation of money for furniture, fixtures and equipment. So it's a smaller sum, if you like, just for the assets, the building itself. There's no particular goodwill payment in there, not that there would necessarily be any, but it's substantially under the value placed on it by the purchaser's own valuers when they were acquiring it.
Thank you. On to question number 4. What was supposed to happen as you understood it, and what actually happened?
Okay, well, in our view, the 7-year term loan should have been renewed to a point in time 5 years beyond the end of the 2008 swap in 2013, and it was not done. We became overhedged, which is the phrase used by the regulator, as a direct result of the bank's actions. If the bank was in any doubt it would not renew the loan, it should not have sold the swap in 2008 on the basis that it would lead to the loan being renewed. Their phrase is rolled over.
Thank you. Question 5. What has been the consequences to you, your business, and if relevant, your family, as a result of what has happened?
Inevitably, there's been substantial reputational damage for the outcome in a significant project, which was awarded Best Property Development in Manchester in 2005 by the Manchester Chamber of Commerce. To have reported my business collapsed into receivership is both inaccurate and damaging to my personal standing. On a cash flow basis, it was solvent, as evidenced by all the unsecured and secured creditors being paid or agreed with Boss to take a particular settlement. I was effectively disenfranchised of what had become my core business over 10 years, from 2001 to 2011, through, I suggest, a conspiracy to cause harm by lawful means.
Question number 6, Stephen. What could the FCA have done that might have protected you from harm?
Well, the first comment I would make is it should have paid more attention to what Boss and other banks were doing with customers and clients and the products they were selling that were harmful to their retail customers and clients. They were clients by definition, after November 2007. And the banks knew that. The banks knew that these sales were potentially very damaging and advantageous to them. They could and should have, this is the regulator, they could and should have used the available powers under the Financial Services and Markets Act 2000, particularly Section 384, Power of Authority to Require Restitution, and Section 382, Restitution Orders. Powers the FCA know they have and they do use, and have had the statutory authority to use them confirmed by the Supreme Court. And I would refer to the case of Asset Land PLC versus the Financial Conduct Authority 2016, a case where those powers were being challenged, but it confirmed by the court, the Supreme Court, the regulator has the powers to issue interim and final restitution orders. The FCA has a statutory duty. The Financial and Service Markets Act is very clear, Section 5, the protection of consumers. So it has a duty to retail clients. Consumers, because they are not professional clients on the Markets in Financial Instruments Directive and defined under section 138 brackets subsection A, Roman numeral 1 of the Financial Services and Markets Act 2000. And the FSA and the FCA failed to carry that out. They willfully excluded some 10,577 retail clients from the 2012 voluntary agreement by reclassifying them as sophisticated. This approach and this act was described by the Treasury Select Committee in its March 2015 report on lending to SMEs as an arbitrary designation. I would say it's not just arbitrary, which it is, but it's deliberate and willful to remove the right to redress by restitution to some retail clients as prescribed under the Markets in Financial Instruments Directive and the FSMA Act 2000, but not others. It is discriminatory. The FSA, as regulator, conspired with the licensed firms to ensure the largest claims would never receive redress. Prevented by section 150 of the Financial Services and Markets Act 2000 to bring a claim for statutory breach, only the regulator could provide redress, and it resolutely refused to do so. Although classified by Bank of Scotland as a retail client in accordance with the Markets in Financial Instruments Directive Annex 2, and being subject to an instruction from the regulator, and I would refer to Clive Adamson's letter, Director of Supervision, Conduct of Business Unit, dated the 29th of January 2013, we were overhedged. And in those circumstances, the instruction by the head of supervision was to tear up the swaps contract that extended beyond a loan term. Bank of Scotland did not do this. Bank of Scotland received this instruction from the FSA, never thinking it would be put in the public domain. So they just willfully ignored it. The public could only find out about the 2013 instructions from the regulator to the bank when they were published in the Addison letter several years later after pressure from the Treasury Select Committee.
Question number 7. What interaction have you had with the FCA about your case?
I've had correspondence, I have a correspondence file with the regulator. It starts with polite responses by them to questions I've not asked and fails to answer the ones I have asked. After several more letters, the FCA say they have nothing more they can usefully add and terminate the correspondence. The FCA does make it clear they do not deal with individual cases and complaints against any licensed firm. They've taken a position on the banks that the FSA 2012 voluntary review deals with all possible claims. It has not, and they know that. The FCA has now spent years defending its own position, which ignores the rights of retail clients to be treated equally and not reclassified in an arbitrary way that leaves no prospect of any extrajudicial process envisaged under the Financial Services and Markets Act 2000 and indeed MiFID, fully transposed into UK law in 2007. They have argued that the selling of swaps associated with loans is not a regulated activity. The FCA failed to grasp that any person, legal or personal, who lends money as a business has to be licensed, and it is a criminal offence not to be licensed. Reference section 19 of the Act. Therefore, the business of all banks is licensed and regulated. For certain products, such as domestic mortgages, there's a more detailed set of rules and guidance. But it is conceptually flawed for the FCA to say residential mortgages are regulated and commercial loans are not. It's a convenient, if inaccurate, statement to avoid responsibility for its own failings as a regulator. My complaint is not about the term loan contract, but the collateral contract to that term loan, which was a more detailed regulated activity. And the reference for that is the note to the section in the Act, note 781, bullet point 8, to section 22. And that refers as an example to interest rate swaps being a regulated activity. And that is set out also in the regulated activities order of statutory instrument 2001 stroke 544 para 85, and described as an index or other factor designated for that purposes in the contract. The 2008 ISDOR fixed contract refers to LIBOR as the basis of calculation of the floating rate of the swap. LIBOR and ISDOR fixed are indices. Then the loan itself, and under the established legal principle of cause of action for collateral contracts, I would refer to Shanklin Peer Limited versus Dettel Products Limited, 1951, was actionable by the regulator. It willfully chose not to take any action.
Question number 8, Stephen. To your knowledge, what did the FCA do about your case?
Well, nothing, other than initial replies to my letters as I've described above.
And question number 9, do you believe the FCA could have done better once they became aware that you had suffered detriment?
Yes. As a class of retail customers, the FCA had a duty to perform under the 2000 Act, the Financial and Service Markets Act. They are like a fire brigade, but they don't attend the fires. They worked with the offending banks to limit the bank's financial liabilities by excluding retail clients from the extrajudicial redress the 2012 reviewed offered. The spurious criteria of the selection of retail clients, I believe, was very reminiscent of the Nuremberg laws in Germany in 1935. The right citizenship law that at a stroke removed rights previously held by all citizens prior to the passing of this law. The criteria agreed by the FSA was arbitrary, as described by the Treasury Select Committee. The criteria was not introduced following the rulemaking provided for under the Financial Service Markets Act 2000 by the FSA or by statutory orders from the Treasury, which would have gone through Parliament, and that's under section 22. In any event, such orders and or rules could not be brought forward in that way as they offended the provisions of the Markets in Financial Instruments Directive, and that's referenced as 93/22/EEC, known as MiFID, with regard to the designation of a professional trader. And if you weren't able to be designated under the annex as a professional trader, then you were a non-designated person, and that's become known as a retail client in the UK. The bank had a duty to classify the client, be it a legal or natural person, before any trade of derivatives. And the Bank of Scotland Treasury classified my company as a retail client.
Question number 10. What would you say about the FCA's effectiveness and timeliness in taking action to protect other business owners from this kind of harm?
I'll be blunt, the FCA is a failed institution of state. I only know of its conduct in the mis-selling of interest rate products to retail customers, renamed clients after November 2007. And that's the basis of my summary opinion as to the FCA's conduct and effectiveness.
Question number 11. How helpful has the FCA been to you and others affected in securing redress from the financial institutions that have caused you harm?
They've been no help whatsoever. In fact, they've been the main obstacle to redress. Set up as a regulatory body outside of the courts under the Financial Service Markets Act statute, the courts are unwilling to insert the law of contract or common law torts into statutory regulatory processes. The courts are right to take that view. The criminal law is possibly more helpful because after many years of fraud being treated in a fragmented way, the 2006 operative from 2007 Fraud Act is much clearer to prosecute than was previously the case. Private prosecutions are perhaps the way forward. No time limitation and no costs awards, unless proven to be of a malicious nature, can be granted or given. The licensed firm has liability for its employees and former employees. However, even with the Reading fraud case involving Bank of Scotland, that case involved an expenditure of £7 million of public funds to investigate and then prosecute the case, and jail sentences amounting to more than 50 years handed down. Lloyds Bank, now the owners of Bank of Scotland, of course, have failed to settle the claims of victims. It's an ongoing problem or issue for the victims and indeed the bank. The FCA has done nothing to accelerate those settlements, even though the bank, as an FCA licensed firm, has been found liable for the criminal acts of its employees and consultants, as well as facilitating access to those customer clients of the bank and confidential information about those clients, circumstances in breach of bank confidentiality. The FCA is under various duties under the Financial Service and Markets Act, and so failure to perform those duties, it is plausible to say, is misconduct in public office. The FCA is carrying out a function of government under the Financial Service and Markets Act 2000, and so is a public body for the purposes of this common law criminal offence.
Thank you, Stephen. On to question number 12. How effectively did the FCA act to prevent them doing it again?
I'm not aware the FCA has changed anything. If the banks can abuse their customers, they will. The culture has not changed. The FCA refused to use their statutory powers against banks, preferring a lessons learned approach, which simply means the banks pay a reduced fine, 30% discount, and continue unaffected. The fine is paid by shareholders. That means for BOSS, and Lloyds and RBS, the taxpayer, as a past and current substantial shareholder, picks up the bill. The fine levied by the regulator goes to the UK Treasury. There is no restitution for customers stroke clients. There is no penalty or other sanction applied to individuals in the offending banks at any level. After 10 years of employment, the chief executive of Lloyds left recently £60 million richer, according to the Telegraph on the 12th of June 2021, and with a knighthood for services to mental health and banking. The tragic irony of that public award for many customers who have suffered mental health issues resulting from their treatment by Bank of Scotland and Lloyds is not lost on them.
Question number 13, Stephen. What are your thoughts on any shortcomings at the FCA?
I start from the fact the Financial Service Markets Act 2000 was a robust piece of legislation, ambitious in its scope with wide powers of action available. The regulator was the best equipped regulatory army to take to the field. We now know it was poorly led from day one. The lobbying of the banks was effective in persuading the Treasury and others like the Secretary of State for Business, Industry and Skills, BIS as it was, who has the same powers as the regulator, failed to act once the shortcomings of the regulator became known. A fail-safe feature of the Act never used by the executive. The regulatory regime was built on two legal concepts. One, strict liability for irregular conduct, a bit similar to the Road Traffic Act, with very little opportunity to offer a defence to conduct known to have occurred. And two, restitution, the principle that when misconduct is found, the parties should be put back to the position before the event occurred. And this was following the 1990s scandal of selling swaps and other derivatives to local authorities that proved massively disadvantageous to those authorities. Fortunately, the House of Lords ruled in the leading case that local authorities had exceeded their powers under the 1972 Local Government Act. And so all swap contracts were null and void. Restitution, not damages after proving a loss, was the limb of the law that was applied. And the reference for that is the Hazel v Hammersmith and Fulham London Borough Council case of 1992, which is an appeal court decision. That is how the Financial Services and Markets Act 2000 is framed, with irregular conduct the offence and restitution being the remedy for both parties. Restitution does permit consequential loss to be considered as part of any fair assessment of the amount of restitution.
And question number 14, what are your thoughts on whether the FCA lacks the powers that it needs, or conversely, that it doesn't make good use of the powers that it already has?
Excuse me. The FCA, in my view, has all the powers it needs under the current legislation. It's had them from day one, in other words, from 2000. Parliament is not at fault in this. The line of reporting to the Treasury, however, does compromise the independence of the FCA. Having a Secretary of State with the same powers was the check or balance that has not worked. The Treasury has powers under Section 404 to review past business that it's not used. The FCA may lack human resource and skills. That can be dealt with by increasing the levy on financial services until it becomes more cost effective to the licensed firms to comply with the regulatory regime. The levy could be stepped, with the largest entities paying the most and the Treasury contributing from the fines levied. It is pointless giving any organisation statutory powers if they are not used and the organisation is not well led. I do not agree that proper regulation will result in banks leaving the UK. Those that do and are constituted as the Bank of Credit and Commerce International, BCCI, are welcome to leave. BCCI's collapse may have cost the Bank of England its loss of regulatory oversight to Parliament's new regulator, but it has not performed any better, and some would say much worse, as more banks failed in what has been described as a systemic collapse in 2008.
In general terms, how would you describe what it's been like dealing with the FCA?
Totally unsatisfactory. A complete betrayal of Parliament's intention and a work of fiction that the original legislation was defective to avoid acting on circumstances known about and evidence received. The FCA criticism of the legislation is easy for the FCA to make in the full knowledge the parliamentary persons who drafted the legislation have no right of reply. I think Private Eye's moniker, Financial Complicit Authority, is well deserved.
Question number 16. What is your perception of the culture of the FCA, and what do you think about it?
Being at the FCA is a step to something else. Within the FCA, there is a hesitancy and a perception of fear of offending the constituency of licensed firms, particularly the bigger players, such as the banks. What we saw in the 1990s and 2000s will happen again, in my view. Those events only serve to highlight the need for an effective regulatory framework and also an effective organisation to operate within it. The Financial Services and Markets Act 2000 provided the framework. The culture of the FCA has undermined that framework. A more qualified person to speak on this is Dame Elizabeth Gloucester, following her report into the collapse of London capital finance. As a former judge, she's concluded the FCA had appropriate powers in that case, but not appropriate policies, and was overly cautious. Her detailed look at the issues in that case only serves to confirm my impression of the FCA gained from my limited interaction with it.
Thank you, Stephen. And now on to question number 17. Have you ever complained officially about the FCA? If so, tell us about that. Thank you.
Yes, I wrote to my Member of Parliament, who was then Mr. George Osborne, who was at the time also the Chancellor. Quite frankly, he was not interested at all and not willing to see me. A couple of short letters thanking me for bringing the matter to his attention in a file of information he had requested, which was sent to him at the House of Commons, and then silence. Perhaps he felt conflicted as Chancellor because the Treasurer had specific duties and responsibilities under the Financial Services and Markets Act 2000 that he would not prefer, or he would prefer not to be looked at or explain why those powers under the Act were not used.
And question number 18 now, Stephen.
Yeah.
What do you think about possibilities of conflicts of interest at the FCA?
Well, in 2016, the United States Congressional Review into why the London headquartered bank HSBC, that's the Hong Kong Shanghai Banking Corporation, did not lose its banking license in the USA for money laundering South American drug cartel money, found George Osborne, then Chancellor, and the FSA supervisory section were lobbying the US Treasury Secretary not to remove or cancel HSBC's license. BlackRock was a major shareholder in HSBC, and according to the Guardian newspaper, the share value was about 9 billion sterling in BlackRock, as reported on the 6th of April 2017. The then chief executive, then chairman of HSBC between 2003 and 2010 of that bank, Stephen Green, now Baron Green of Hurst-Pierpoint, was appointed a minister under the Secretary of State for BIS in 2010. BIS, of course, the Secretary of State for BIS was the Secretary of State also responsible under the Financial Services and Markets Act 2000. The 2010 coalition government led by David Cameron, and he was to advise George Osborne on Treasury matters. Before George Osborne left politics, he took up a number of roles, including an advisory role with BlackRock on £650,000 per annum, that's £13,000 a day, plus undisclosed shares in BlackRock. And that's a article written by Niles Pratley. HSBC did not lose its USA license because it entered into a deferred prosecution agreement, a DPA, with the US Justice Department that requires all criminal offences of HSBC to be admitted and HSBC to be the subject of supervision by a Justice Department appointed person. The directors and management are not permitted to deny or conceal the DPA. And I would, the reference for that is the US Senate Committee on Homeland Security and Government Affairs Permanent Subcommittee on Investigations 2012. And there's also been reporting of that in Private Eye. The purchaser of my company's assets was also a main board director of HSBC in 2001 to 2007. Our assets were purchased off market and never offered to the open market by the boss appointed administrative receivers. The BIS Secretary of State, Dr. Vince Cable, was not inclined to get involved at all as the designated Secretary of State for the Financial Services and Markets Act 2000. It seemed the Treasury was the lead government department, although it has no direct role under the Financial Services Markets Act Part 15, Injunctions and Restitution. The Secretary of State has a function under Section 384, Power of Authority, to require restitution, and Section 382, restitution orders, to be exercised if the regulatory or regulator, brackets competent authority, does not. The FCA argued the FSA 2012 voluntary review for mis-selling in 93% of cases they looked at of derivatives, swaps, interest rate hedging products, collectively known as IRHPs, would provide quicker resolution and compensation for complaints than individual claims. Those retail clients excluded, arbitrarily, you may recall, from the scheme could use the courts. The FCA said this in the full knowledge the courts in Grant Estates versus Royal Bank of Scotland had already ruled legal persons could not bring an action for statutory breach because of its interpretation as a matter of law under Section 150 of the Financial Services and Markets Act 2000 bars such actions. The Grant Estates case was not appealed. The potential conflicts of interest between the executive in the form of the Treasury, the regulator as a non-government agency, an NGO, with a line of responsibility to the Treasury, and the outlying position of the nominated Secretary of State for BIS, with the same powers as the regulator, all in theory answerable to Parliament, is at best cumbersome and at worst conflicted in many ways. They may all have differing short and long-term objectives that will be exploited by those being regulated, their lawyers and lobbyists. The only people with no influence or knowledge are the bank's retail customers and clients. The very people the Financial Services and Markets Act 2000 sought to protect by stopping abuse and individual abuse by the irregular activities of those individuals are registered with the FCA as approved or authorised individuals and licensed firms. I'm not covering the Prudential Regulation Authority because that didn't come into existence until 2013, but the Treasury has powers under Section 404 to review past business, and Section 14 for regulated activities defined in my previous answer, but it has not done so.
Thank you again, Stephen. And your next question, question number 19.
Yeah.
If you could change 3 things about the FCA, what would they be?
I'll take these in no order of priority, but in the case of the first of the 3, it might be to say that the Financial Services and Markets Act 2000 could be amended again, because it has already been amended in 2013, to make the regulator independent of Treasury and directly answerable to Parliament, like other public officials appointed under statute to carry out specific duties. The second possibility is that the regulator should start from the presumption the regulated are at fault, unless they can show they are not. In other words, strict liability. This may seem unfair, but that is exactly, for instance, how the Road Traffic Act works for the rest of us. And it stops the courts being clogged with defence cases of no merit, but the right to bring them. If the banks have the right to bring defence or counterclaims, they will do so to suppress or disrupt the regulator. I think the third possibility is that the FCA has powers to carry out reviews, section 13, gather information, section 165, investigate, 170, section 170, and section 284, and chapter 6, investigations, and schedule 15, and it should do that as a duty to actually, if you like, attend the fire and put it out if complaints are received. If it finds evidence to support the complaint, then it should be quick to issue a restitution order under section 382.
Question 20, Stephen. What positives are there about the FCA that you'd like to comment on?
None. How can there be any, given we are still waiting for the regulator's report into the collapse of Bank of Scotland 12 years after the event and 4 years since it was last promised in 2016. Also, extrajudicial redress for the 10,577 retail clients arbitrarily excluded from the FSA 2012 voluntary review remain unresolved. The new Banking Resolution Service, BBRS, may do better than the FSA 2012 voluntary review, but there are still arbitrary criteria for eligibility to the BBRS, which undoubtedly will exclude most of those 10,500 clients. The number doesn't seem to have changed, by the way. The number I'm quoting is referenced on the FCA's website on the 14th of May 2020.
Thank you again, Stephen. Question number 21. Do you believe there ought to be spot checks by the FCA on regulated and or unregulated firms, perhaps similar to the spot checks by VAT inspectors?
Not especially. The powers to act swiftly are there in the current legislation. It's the will to do so that matters. What might make a real difference is if whistleblowers received a proper hearing, confidentiality, and be rewarded, as in the United States. Not every person in financial services is corrupt, a thief, dishonest, or otherwise an inappropriate person to work in financial services. For the honest people, the culture may be or becomes uncomfortable. No one helps them. Internal complaints procedures do not work if complaining about the very activity approved of by the senior management and the individual is being instructed to carry out. They are betraying the customer's trust in the bank as an institution by selling unsuitable products to the customer, relying on the customer's ignorance and misplaced trust in them as an individual, and because of the halo of being FCA regulated. The financial incentive in the form of a monetary bonus they receive for doing so does not excuse them, and they know that. I have met several individuals who left their employment to simply escape the pervasive and, in their view, morally corrosive culture being imposed by their line managers.
Next question, number 22. Do you have any concerns that this court evidence may be counterproductive from your point of view?
That depends on a number of factors, but for the next generation, they may avoid the experience I have had.
23. The FCA is undertaking a transformation project. Do you have any comments to make about that?
I'm not familiar with what that entails, so I can't really have any constructive comment to make at this stage.
Understood. And question number 24, Stephen, and in fact your last question, are there any other comments that you would like to make?
The all-party parliamentary group has, like other members of Parliament on the Treasury Select Committee, paid a heavy price for their interest in and work on this subject. I do recognise that and thank them for their efforts. This is a long way from over, but Parliament must succeed to uphold the integrity of the banking sector that has been severely damaged by these events. It must succeed to support SMEs in all sectors, for they make such a large contribution to the dignity of employment and the opportunities in the world of work.
Stephen Barker, thank you very much indeed for taking time to submit your evidence today by way of this video interview, and also through having provided your written submission to the all-party parliamentary group on personal banking and fairer financial services, call for evidence about the Financial Conduct Authority. We can bring the meeting to a close now, Stephen. Thank you very much indeed. Thank you.
Thank you, Andy.